Hi friends, and welcome back to Contract Law. This is video 2 in the video series for the vitiating factors of misrepresentation and misleading or deceptive conduct. And in the first video, we had a quick overview and then we jumped right into the beast that is misrepresentation at common law. And we skipped over the 4 elements that you need to show for an action in misrepresentation. And now we need to go through the various different types of misrepresentation that you may find. There are 3 categories, and they are fraudulent, negligent, and innocent. And they are principally distinguished by their remedies, okay? Apart from the different elements and all the other things that distinguish them. The main thing is with innocent misrepresentation, you can only rescind the contract. You can't get damages. Why is that? Because the damages that are available for both fraudulent and negligent misrepresentation lie in tort. Obviously, as I said at the beginning of the video, we are not suing in contract here, so we have to kind of fossick around and see where else we might be able to get some damages from, and they lie in actions in tort. And so where you have fraudulent misrepresentation, it will constitute the tort of deceit. Where you have negligent misrepresentation, it will more than likely constitute the tort of negligence. And so you may be able to get damages there if your client is lucky. So looking at each of those in turn, the first category, and obviously the naughtiest, is fraudulent misrepresentation. This is a very, very serious allegation. Essentially, it's a legal finding that the person was lying, okay? There has been a deliberate untruth being said. Because it's such a serious allegation, the courts here have really tried very hard to give every affordance, so to speak, to the person allegedly lying. And the test here, very unusually for contract law, is subjective. And the subjective test is whether that person had an honest belief in the truth of the representation. If the person did have an honest belief, then there was no deliberate untruth, and therefore there will be no fraudulent misrepresentation. Now, because of the nature of this test, it is fairly easy to get around in terms of the defendant just simply saying that they actually had an honest belief in the truth of what they are saying. Now, unless the fact scenario is such that that makes it completely impossible, or there is some kind of smoking gun evidence that the plaintiff can prove that there was a deliberate untruth said, then it's going to be very, very difficult to prove a case of fraudulent misrepresentation. In the case of Darien Peak, the court set out the different kinds of intent that have to underlie a case of fraudulent misrepresentation. So the full statement has to be made either knowingly, that is, you know you're going to tell a lie, without belief in its truth, so you just say something but you don't actually positively believe that it's true, or you say something but you really don't care that it's true or not true, recklessly careless whether it's true or false. So if you make a false statement with any of those kinds of intent, then it may well be a fraudulent misrepresentation. The case of Darien Peak shows just how difficult it is to get up on something like this. In that case, the company had issued a prospectus with some false statements in there. They said that they could conduct their trams with steam and other mechanical power. It had applied for the various approvals for it to be able to do so, but it just hadn't got the consents actually through. And obviously a disgruntled shareholder decided to bring an action for fraudulent misrepresentation and was unsuccessful because the directors at the time they made the statement in the prospectus had an honest belief in the truth of what they were saying. They'd made the applications, they thought that the approvals would be forthcoming. So that shows some difficulty. Contrast that with Edgington and Fitzmaurice. In that case, another prospectus case, we had the company saying that it was trying to raise money for alterations to buildings and purchase of horses and vans. Unfortunately, at the time the directors made the statement, the plaintiff could actually show that the reason that they were trying to raise money was to pay down some debts. And so in that case, because there was the so-called smoking gun evidence, the plaintiff was successful and there was a case of fraudulent misrepresentation. That is the case in which Lord Bowen said that the state of a man's mind is as much of a fact as the state of his digestion. So the company couldn't get out of it by saying that it was merely a statement of intention and not actionable. So, as I said, remedies, rescission and potentially damages for deceit. The next category is negligent misrepresentation, and this is kind of the new kid on the block so far as misrepresentation is concerned. It arose really in the 60s, was refined up through the 80s, and it requires the satisfaction of the same elements of misrepresentation as well as those for negligence. That is, you need to show that the representor owed the representee a duty of care. That is, they were held out as being responsible for providing some kind of information, for example, and they realised that the other person was relying on them for that information. There's been a breach of the duty of care and there's consequent loss. The main case that is usually cited for negligent misrepresentation is Shaddock and the Council of the City of Parramatta. It was an unfortunate case where some people approached the council for information about a property as to whether it was affected by road widening proposals. The council said, nope, you're all good, the property is not affected by any road widening proposals, and you guessed it, it was so affected. Classic kind of situation where you have somebody that is providing the information in a position to know or should know the information. They're aware that the other person is relying on them, and that creates that duty of care. Then there's a breach, then there's loss, then you've got negligent misrepresentation. Again, remedies, rescission, and potentially damages in negligence. I will mention the bit that I didn't mention on the last slide, the very bottom bullet point. You can obviously only get damages in contract if the representation had become a term of the contract. And if that's the case, then you need to choose. You need to choose between damages in contract and damages in negligence. Now, the big difference between the two, and this is the same for fraudulent misrepresentation. When you're seeking damages in contract, you are essentially asking the court to place you in the position as if the contract had been performed. Damages in contract are designed to get the plaintiff into the position as if the contract had been performed. So if you expected to make a certain profit, we call that expectation damages, then they are the damages that you will be awarded in contract. It's very, very different when you're talking about tortious damages. Tortious damages like damages in deceit for fraudulent misrepresentation or damages in negligence for negligent misrepresentation. Damages in tort are designed to get the plaintiff back into the position as if the tort had not occurred. So you're undoing all the bad stuff, right? So often these are called out-of-pocket damages. So you're really trying to just pay the plaintiff enough to get them back to what we call the status quo ante, how they were at the start. Okay, It might sound like a bit of nitpicking, but the differences in these two measures of damages, the contract measure as opposed to the tortious measure, can be quite extreme. For example, a builder expects to make a $100,000 profit on a contract, and in order to make that $100,000 profit, he has to spend $20,000 in materials. The measure in contract will be his expectation loss, that $100,000 profit. If the court gives him that $100,000, it will get him into the position as if the contract had been performed. Expectation losses, okay? If, however, you take the tortious measure, you will get that plaintiff, that builder, back into the position as if the tort hadn't been committed. And in this situation, what has happened is that the builder has relied on the tortious conduct to enter the contract and spend their $20,000. That $20,000 is their out-of-pocket expense in reliance on the tortious conduct. So the court will give them back the $20,000. So as you can see, a very different result when you're talking about damages in contract and damages in tort. The other thing, if you are looking at rescission, you cannot claim rescission of a contract and claim damages in contract, because rescission necessarily unpicks the contract back to the very beginning as though it never existed in the first place. And if that's what you've done, you can't go ahead and sue in contract because there's no contract left to sue on. Yes, makes sense. So that's the difference, very extreme difference between calculating damages in contract and in tort. Okay, the last of our categories is innocent misrepresentation. And innocent misrepresentation really is just defined by being none of the above. It's essentially there has been a false representation that has induced the contract, but no tort was committed. There was no lying, there was no deliberate untruth, so there's certainly no fraud. There was no duty of care there and breach, so there was no negligence. There was just, unfortunately, an incorrect statement made. So your only remedy there is rescission. And they are the categories of misrepresentation at common law. Now we just need to say a few more words about rescission, given that it's the principal remedy in misrepresentation. And as I've just finished saying, rescission is unpicking the contract back to the very beginning, ab initio, to the beginning, as though it never existed at all in the first place. So obviously you can't get damages in contract. If damages are available, they will be in tort. So it makes sense, doesn't it? Rescission will always be available regardless of the category of misrepresentation, as we've just seen. However, because for the most part rescission will be sought in equity, it is vulnerable to what we call bars or limits to the remedy of rescission. Rescission is technically available at common law, but in order for rescission to be available in common law, we have to be able to get what we call precise restitutio in integrum. Precise restitutio in integrum. That means you have to be able to restore the parties to exactly the status quo ante. You have to be able to unpick that contract and put those parties back in exactly the same positions as they were before. If you can't, rescission is not available at common law. And this is why mostly you will be seeking rescission for your client in equity. In equity, we only require that we are able to achieve substantial restitutio in integrum. That means we can, as closely as possible, approximate the status quo ante positions. Okay, you might need to make orders for restitutio to restore money to a certain party, to restore property to a certain party, and to offset damages or losses that have occurred along the way. If you can get the parties mostly back to that status quo ante, then rescission will still be available in equity. But there are a number of bars, and the big bars here to rescission are the ones that I've listed here. The first one is affirmation, and this is where the party that's trying to rescind says or does something that indicates to the other party that, in fact, instead of trying to rescind the contract, they will go ahead and keep going with the contract. If that's what they've said or done, it may well be that the court holds that they have elected to affirm the contract and they will therefore lose their right to rescind. You can't affirm a contract and then rescind, okay? You can't, and equally, you can't rescind and then try and affirm, okay? So it's very careful that your client minds what they say and do once they know they have the ability to rescind, because anything they say or do might well be held against them in the affirmation states. So that's affirmation. The next one is delay, which is sometimes called latches. It gets back to the old equitable maxim that you can't sit on your rights, okay? If your client becomes aware that they have the right to rescind their contract because of misrepresentation, they can't sit around for an unreasonable amount of time and just delay and delay and delay, not make any decision, and then, whoops, all of a sudden try and rescind some years down the track. It's not going to be possible, okay? What constitutes delay might be, in some commercial situations, weeks, might be months, might be years. It will depend on the circumstances, but in all circumstances, the court will use that good old reasonableness as the measuring stick. What was reasonable in that particular fact situation, okay? So that's your issue with delay. Sometimes delay gets married up with affirmation, and they say because of the length of time, effectively the plaintiff has affirmed, okay, because they've just dallied so long, really there's no other conclusion to be made, okay? So that's delay. The next one is super important, third party involvement. And if there is an innocent third party that has crept into this contractual scenario, usually for value, that is, they've provided independent consideration of their own, and without notice of any of the other vitiating factors that have gone on, then equity will tend to hold their rights as paramount. And your client, the party to the original contract that knows and wants to rescind, will lose their right to rescind. This is the classic scenario where you have a rogue involved. There's been some kind of misrepresentation, and then the property that's sold to the rogue is then sold on to an innocent third party. In those kinds of circumstances, the court will prefer the rights of the innocent third party, and the original party at the very beginning of the sad sorry saga that did have the right to rescind before the third party came on the scene will lose their right to rescind. Finally, we have the rule in Seddon's case, which says that if you've actually completed the contract completely, then unfortunately you've lost the right to rescind. It arose and is principally applied in property cases where there's plenty of time to check out the correct situation of things before you actually have to have settlement and the conveyance actually completing. In those circumstances, the court is much less forgiving and you'll lose your right to rescind. Whether or not that rule in Seddon's case can be applied to other non-real property cases, there's been a very long academic debate. The rule in Seddon's case, really, the consensus appears to be that it is not really applicable outside the property cases, but I'll leave you to ponder that in your own time. They are the bars to rescission. Super important to remember that rescission is a great remedy, but it certainly is a vulnerable remedy, and there are a number of bars, as we see in that photo, but not very pleasant bars to encounter. So that is misrepresentation at common law. And we have once again hit the magical 15-minute mark, so I will leave it there for now, guys. I'll see you in video 3 for misleading or deceptive conduct. So bye for now, guys.